And we are live.
Good afternoon, everybody, and welcome to the Vermont State Senate Committee on Institutions. My name is Joe Benning. I am the chair of this committee. I am a state senator from the Caledonia District, which is all of Caledonia County and the 6 northeasternmost towns in Orange County, which happens to include the town of Newbury. We are a committee of 5, and I'll just go around my screen. I have Senator Dick Mazza from Colchester Grand Isle, Senator McCormick from Windsor County, Senator Ingalls from Essex Orleans, and Senator Parent from Franklin County. We are continuing a conversation about many of our brick and mortar institutions. Our brick and mortar institutions are essentially what this committee is all about. For YouTube purposes, since we are live, if you are not testifying, I would ask that you mute yourselves if at all possible and wait for your name to be called. I have a list of witnesses here. Tony O'Mara, you are the first one that I have on my list. I do understand from moments ago that a different order of folks was set up in place. Yeah. So I may actually hand the floor over to you in a moment, but let me give some ground rules. I do understand that this issue we are talking about is rather contentious. I also understand that it is in the midst of litigation. This committee is not going to inject itself into that litigation. I promised Tony a couple of months ago that we would allow people to come in and testify as to what their frustrations are. We do have responsibility in the capital bill of making sure we have institutions that meet the standards and the needs that the state has to have. And in this particular situation, we were presented with the preliminaries about a year ago with respect to the state closing Woodside and looking elsewhere and targeting Newbury as a potential place of replacement. So we're familiar with the background facts. We are not up to speed with what has happened since that proposal came to the town of Newbury. But I want to make very clear, you folks have been invited here to vent, if you will, but we cannot make any decisions and we are not going to interject ourselves into the litigation. I do understand Representative Parsons is here in support from the town of Newbury. I have not asked for either the state or the town's official representatives to be present for this conversation, primarily because you are all involved in litigation, and I did not want to have us having some kind of an impact on that. The other ground rules are basic YouTube rules, if you will. First off, this is a family-oriented environment. I know that there's lots of people that are frustrated about various things, but we try to keep our language as clean as possible. And I hope and respect that all of you will do exactly that. If you are using language that some folks who are in the public may not understand, for instance, I'm a lawyer. I know very well what a 12D motion is. I don't think anybody else on the screen knows what that is. And if something like that were to pop up in your testimony, I might stop you and say, can you explain to us what such and such is? And I don't want you to feel like I'm being rude. It's just one of those basics. We all like to be on the same page with what we're hearing. The way that this works, we will go around the room and allow everybody to say whatever they want to say. But I do ask at the beginning of your testimony that you tell us who you are. And if you happen to be a resident of the town of Newbury, to let us know that as well. And if you have a specific interest, whatever job position you may have, for instance, or let's say, for instance, you live on the same road as this project, we'd like to have that information as well, just up front, so we have some understanding of who you are. I don't know whether you have any questions. Tony, I'm going to look to you to see if I've been clear enough in my explaining. And forgive me, sometimes I talk like a lawyer and sometimes I talk like a politician. I am both, and if I've confused anybody, it was not intentional.
No, thank you very much, Senator Benning, for the invite. I think that was pretty clear on the ground rules, and I was thinking as you were speaking, I don't think I'm covering anything regarding future litigation, because everything I'm talking about is essentially backward looking. It's already been discussed very openly in Act 250 and the DRB hearing and so on and so forth.
Sure. Tony, do you have the order of events that you prefer, the order of names?
Yes, I do. I did send it to Alex, albeit at the last minute. I'd like to keep him on his toes.
Okay.
But,
I'm still putting out fires on my computer here, trying to reach that email message. So I'm going to try to do that. But for now, I would appreciate it if you would just take the bull by the horns, and when one person is done speaking, introduce who the next character would be.
Okay, well, thank you very much. Okay, good afternoon, everybody.
Welcome to you all. I forgot to say this is January 12th, and I want to welcome you all to Senate Institutions.
Yep, thank you very much. My name's Tony O'Mara. I'm a resident of Newbury, Vermont. I do live on Fish Pond Road, which is a short distance from the proposed facility. And I do thank you for the invitation to speak here. This is the first time I've done this. Hope probably the last, who knows. So, you know, I'm not quite sure how it all works, but I think the guidelines were good. There are other residents here today who we talked about. So I know you were looking for a wide perspective, different views, and hopefully you're going to get that from this. That's everything I'm going to say is really from public data, and I can provide that if necessary. I did provide to Alex about an hour ago, which, you know, I know you guys won't have time to read it. A long form version of what I'm going to talk about, just if there's any questions, but please feel free to reach out if you need anything else after this. So I guess, you know, starting about just under a year ago, February 2021, most of us in Newbury started to become aware of something that was going on in Newbury around a project proposal that had been approved to basically replace Woodside and build it in Newbury. You know, it's pretty close, and it was in Newbury's conservation district. We also learned it had been going on for about 6 months, that we really didn't know about it. And apparently there was no real attempt to involve or communicate with the community on this until we all found out from each other. Essentially, people were just talking about it. So I think it's reasonable to say that no one in Newbury really disagrees with the urgent need here to replace Woodside or the program. And everything about the proposal was pretty reasonable, except for 2 or 3 significant facts. It's not compliant with the town zoning ordinances for the chosen location. It's not able to be supported adequately by necessary services, and it's going to have an adverse impact on the community. It's unfortunate, I think, that, you know, cutting to the chase here, the assertion that it was an allowed use and there was already a permit in place has been used as a basis for obtaining the project approval, in my opinion, and repeated continually in several hearings all through the last year. So, you know, on this matter, I believe DCF's made assertions to the oversight committees that are not supported by the facts, and hopefully we're going to go into those, and I'll try and explain it a little bit better along with everyone else. It's easy to I'll just hit this head on. It's easy to paint Newbury as the bad guys in this and dismiss it. This is NIMBY, right? You know, we just don't want it here because, you know, we've turned out not quite to be the formality that they expected. And to some extent, it's being implied now that we're somehow blocking the state urgent need going forward, which, you know, is not really the issue. You know, my view of this, and I think it's shared by others, is if a Newbury property owner wants to do something that's out of compliance, and then opposing it is not being NIMBY, it's entirely reasonable position to take. And just because the owner's, you know, a wealthy private company with state backing with tax dollars doesn't mean that it's compliant or automatically gets a pass. So it's an entirely reasonable position for the residents of Newbury to take. And we have been accused of being NIMBY quite a lot, those of us who are vocal about opposing this. I mean, frankly, if you believe this is NIMBY, then you don't really, it challenges the entire planning process and zoning process in the state. But the community opposition to this is measured, reasoned, and it's really not complicated. And hopefully you'll hear that today. Throughout the process, I mean, I'll hit this one head on as well. There's been a lot of attempts to discredit the opposition. I don't want to complain too much about it, but we're basically being characterized initially as loud and local minority, the people down the street. So that's me and a few others around here. You know, we're the ones making the fuss, which is not true. Turned out totally not to be true. Then saying that we're against the whole notion of needing to treat the population, which is also absolutely not true. And then the worst one, simply that we're lying. And you know, I'm quoting here. Our reaction is bluntly an ignorant one. We use a pejorative to misrepresent the facts and have perhaps other considerations and motives for doing so. So it really sets a little bit of a adversarial situation right out of the gate. And actually, there was some quite insulting remarks about the community at the DCF, made by DCF through their attorney at the DRB hearing, which, so, having been accused of having other motives, I got to say my only motive is the correct interpretation and enforcement of zoning law as it applies to this project and this town. A realistic and objective assessment of the lack of necessary services at the location, and do my best to point out that I believe the integrity of the legislative approval and oversight process has actually been challenged in this whole thing. We can all appreciate there's been a considerable amount of work that's taken place to date on this project. I fully understand that. But it was all built on a pretty shaky foundation. If you want to take a step back and look at it, in my opinion, the first thing that should have been addressed is land use and zoning for the repurposing of the building before you totally went wholesale down the street. Because when you actually dig into the facts, you'll see that it was kind of tenuous right out of the gate. So with that in the context, and the fact, Senator Benning, you did say it was a deep dive. I am an engineer, so I'm kind of just going to run through a few facts. I don't want to get bogged down in too many details, but I just want to go over the permit history. And I'm talking pre-DRB hearing. This has nothing to do with the DRB decision. This all happened previously. 2014, VPI applied for a permit, basically in Newbury at that facility, saying VPI will purchase the existing bed and breakfast property for use as a pre-vocational outdoor educational / experiential learning center. All right. And the application was signed by Beckett. That 2014 application further said, to comply with the Newbury Town Plan, the project's located in the conservation and natural resource area, and the conditional use review by the town found that by maintaining 278 acres as an outdoor classroom for environmental and agricultural studies, the project meets the goals of the town plan. That language exactly mirrored the Newbury DRB's decision back in 2013, 2014, which said the same thing, maintaining the 278 acres for the outdoor school meets the goals of the town plan. So there we have it. The permit was issued stating very specifically, and it states, this permit specifically authorizes the use of an existing B&B property as a pre-vocational outdoor education experiential learning center. And it goes on to say there's no changes to the building, access parking, and so on. So for about 3 years, VPI operated various schools at that location, but they eventually closed. And in 2018, VPI opened the Vermont Assessment Center at Newbury, VACN, in collaboration with DCF, under contract with DCF. It was a change in use, and at the time it wasn't disclosed to anybody that it was a change in use. And that operated till 2020 when it was closed to make way for this new facility. It was a short-term residential program licensed as a residential treatment program by DCF. But, the point here is DCF license isn't a permit. The DCF licensing regulations say very clearly that the governing authority, which in this case would be Beckett, is responsible for ensuring the continual compliance and conformity with zoning law, with laws, regulations, blah, 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 including zoning. So there was a requirement, even though it is licensed. So the prior program was opened, in my opinion, non-compliance with a land use permit. And then that non-compliance was subsequently used as the basis for selling the project, originally to DCF, then to the legislature. Persuade the oversight committees there were not going to be any issues throughout the following months. So the LOI was signed in September 2020, and legislative approval was granted in November 2020, I think. Then in December 2020, that's 3 months after the LOI, Beckett submitted to Act 250 a project review sheet to assess whether they needed an amended Act 250 permit that basically said they wanted to convert a pre-vocational outdoor educational experiential learning center to a juvenile treatment center, a secure juvenile treatment center. In my mind, that's tacit acknowledgement that they knew they didn't have the permit. They've asked to change it from and to. So the jurisdictional opinion was issued at that time by Act 250 coordinator, basically saying there's no material change, and that we take issue with. There's a lot of material change that wasn't disclosed, but that effectively leaves the permit in place. So it already exists. So the Act 250 permit that was issued in 2014 is still in effect today at that facility, and was through the entire process. So if you go back about a year, I mean, I've got a whole list of times that the permit came up during oversight committee hearings. I don't want to just read them all, but they are in the document. Starting about a year ago, it's Senate Judiciary, basically said legal zoning issues are very minor because we have a permit in place. Senate institutions, in February, same thing. Same in Human Services, February 12th, all the way through to August the 11th, where it was repeated in Joint Legislative Justice Oversight Committee. The thing is, none of these were correct, right? They turned out that all the statements, many statements that were made to the committees, there wasn't a permit for the treatment center at the location. The language is specific. It was made clear by Commissioner Brown in several hearings that a key factor in the selection of Beckett's proposal by DCF was that it was already operating as a treatment center and had the proper permits in place, which is a very good selling point. I could see why you would do that. So my view is, due to the tenuous nature of the permit relative to the zoning, they must have known there'd be an issue, right? At this point, but made no effort to consider contingency planning, despite saying they would. So again, 1 year ago, same meeting that I just quoted earlier, Senator Sears asked the very direct question, do you have a backup plan if the community says absolutely not to the Covered Bridges Treatment Center? And the answer was, we're working through the contingency plans using the other providers who responded to the RFP. There have been other conversations, and what he said was, so we would be able to move in a different direction if there are issues with the placement of this treatment program in that community. To me, that sounds like if they don't get it, they move on. So on May 12th, to House Human Services, Judith Rex, who was presenting the status at the time, said, well, if the Development Review Board denies the application, then the state's going to have to regroup and figure out whether we want to appeal or move to Plan B, but there isn't a Plan B. So they're very clear about not even thinking about contingency at this point. So a decision must have been made at some point not to work on the contingency plan they told Senator Sears about in January. It would be good to know what were the factors behind that decision. And as far back as May, they're being very open about having no backup plan. The interesting one to me was, and many others in Newbury, was on August 11th, there was a joint legislative justice oversight meeting where Plan B for Beckett was on the agenda. And there was a lot of us very interested in this at that time. But when it came to the discussion, it was just like a rose-colored glasses review of the entire project. No mention whatsoever of contingency, so much so that CAX reported it with almost implied certainty at that point. So, many of us here were wondering what happened. Something must have happened to take that off the agenda. So I guess what I'm getting to, so despite statements to the contrary, DCF basically doubled down on Newbury, the problematic location, committing, to what is now a protracted legal process of uncertain timing that, in my opinion, does nothing but waste time while the critical state need isn't being met. So the decision behind abandoning Plan B, or if they ever really intended to have one, should really be investigated. It's the best interest of the state, in my opinion, that an alternate plan needs to be kicked off now and the project redirected, rather than wait for the result of an appeal. Additionally, late last week, I was listening to one of the hearings where Commissioner Brown confirmed the state's paying for the appeal, which is interesting. And all of, because he said it's part of the permitting process, and that was part of the side agreement. But speaking as a taxpayer here, and this, I guess, applies to everybody, I don't believe this is appropriate, given that at the time that side agreement was signed, there was no suggestion they even needed permit activity, let alone going through litigation. It was the business was awarded to Beckett and the consulting agreement signed. The legal cost an order of magnitude higher now, and it's entirely due to Beckett. Taxpayers shouldn't be paying for this. So, just my opinion. It's important as well to look at the true purpose of the building. And again, this isn't getting into appeal. This is getting into what was presented to the Act 250. And it also plays into a lot of what we perceive as misrepresentations in the town. The true purpose of the building's important. Act 154 that set the whole thing rolling was very clear. It's basically a building or a purpose for adjudicated youth charged with delinquent or criminal acts who require secure placement, described as a target population. That's pretty clear. And that was awarded to Beckett, and there's extensive physical modifications to do this. $3.5 million ish. It's probably going to be higher by the time it's done. And that is a whole list of security features. And I won't read them all out, but, concrete wall blocks, 24/7 surveillance, infrared cameras, 15-foot high fence with a sloping top, with anti-climb mesh, all that sort of stuff. Clearly, the design of the proposed facility at Newbury meets all the conditions defined by the state of Vermont's policy and procedure manuals to be called legitimately a secure detention facility, because it is. It can also be legitimately called a correctional facility once the youth are adjudicated into it. Additionally, the DCF licensing regulation for treatment programs in Vermont defines a secure program the same way. It details all the inoperable doors and windows and then says, i.e. a detention program. The reason I'm saying this is there's no ambiguity here. The facility will be a detention center. And it has to be considered that for the purpose of zoning and community concerns. The problem is that, I don't care what euphemisms use once it's up and running, but it really does need to have an accurate description when you're dealing with the community and dealing with zoning authorities and so on. Despite the fact that it actually meets all the definitions, the Newbury, DCF and Beckett have pretty much dismissed every time we even mention correction facility as just the resident's hyperbole and suggesting questionable motives for doing so. Like I said, at the DRB, they actually stated clearly the individuals have rejected the notion that the purpose of the program is to treat a needy population, and instead have sought to characterize the home as a prison and a detention center. And this was said under oath, that we use the pejorative of saying this is a detention center. That is incorrect language. That's not true. It's not correct. You might think we're making a big deal out of nothing, but it's actually quite relevant as we go forward in this. Then we had an abrupt change in direction where the Act 250 Commission were advised that this is some 11 weeks after the original permit request, that it's going to go from a school treatment center or a treatment and educational center, and the use of the site is not changing, to a residential group home for the mentally disabled. Right. This was a very sudden change after the DRB hearing, after the first DRB hearing. So they now say the primary purpose of this facility is a residential group home for the disabled solely to avoid zoning authority. That's the only reason behind it. And I believe a complete misrepresentation of the facility's true future use and target population. The issue here is actually that in order to comply with this new strategy, they have to make the assertion that all adjudicated youth requiring secure placement in the facility will be by definition mentally disabled. This is required for them to make the case that the facility must be treated as a group home for the disabled and thus treated as a single family residence for zoning purposes. Now, as the facility must accept all high-risk adjudicated youth with a no reject, no eject, this is a blanket assertion that all youth offenders charged with a crime and judged at risk are deemed to be mentally disabled, or more disturbingly, requiring an evaluation with a seemingly preordained outcome so that the proposed Newbury facility can be used for that adjudicated youth. The associated assertion that future residents are prejudged simply to avoid the legitimate permitting process, to me, is really disturbing. Even more so because it was backed up by an affidavit from the DCF commissioner. The terms group home or mental disabilities or mentally disabled were never used anywhere in all the documents that I'd looked at from the original RFP in January 2020 onwards until that change in strategy at the beginning of October. To me, it's an outrageous approach, and I'm actually appalled that DCF would seek to label adjudicated at-risk youth as having a mental disability under the law, with a long-term consequence and potential stigma of such a claim may have for the individuals in question, all for the purpose of receiving favorable land use decision for the facility. The discriminator that sets this facility apart from any other similar program in the state is the mandated and approved purpose specifically for adjudicated youth in DCF custody, specifically who require a locked, secure placement. Whether they're mentally disabled or not has no influence whatsoever on the decision to place a youth at Newbury, or whether they continue their stay at Newbury. So they also, as a throwaway, they misrepresented they actually stated that the legislature defined a single family residence in one of their submittals, even though they didn't. If you go through the approval memo, it's very clear what is being defined. And it's not a group home for the disabled, it is a secure locked facility for adjudicated youth. So then we move on to shortly after the period denial. It was reported in the media that the state plans a civil rights challenge, saying the Newbury DRB decision disregards applicable civil rights law. You know, that in my mind is simply ludicrous. If you really want to look at it, the rights being disregarded are the youth who DCF will prejudge as mentally disabled or will be assessed, by a process that will preordain outcome that they will be found mentally disabled, as this will be needed to placement Newbury. It's a prejudicial clinical ruling required for the single and only purpose of being the basis of the permit strategy. I personally believe that's not acceptable. Despite all the statements to the contrary, I'm just reiterating, the primary and only reason the youth will be ordered to be placed at Newbury is for a secure placement due to public safety concerns and the fact they have been charged with a crime and are considered a risk to the community or themselves, not mentally disabled. Based on these definitions here, DCF is clearly wrong, in my opinion. The urgent state need is not for a secure group home for adolescent Vermont boys with mental disabilities, as DCF have now claimed, but it really is for a secure facility to confine and stabilize at-risk, justice-involved youth. Complete misrepresentation, in my opinion. And I'm really sure the Oversight Committee members wouldn't condone such draconian and Orwellian measures being planned, or the blatant misrepresentation of the building purpose solely to evade due process once all the facts are on the table. So just moving on slightly, I'd like to reference a memo from DCF Erica Radke to Senator Ginny Lyons on July that mentions me by name. So I really do want to talk about this. I've seen my name in several emails and so on, but it regards an email I sent to Senator C as pointing out the groundswell of community opposition against this. And in the context of Commissioner Brown making a statement not to move the project forward without community support, and urge that Commissioner Brown honor his commitment. I've listened to it many times. I won't read the transcripts of it now, but I do have a video of it, which I did forward to Alex if anyone wants to look at it. I cannot see how you could take it out of context. This was done the day after the first town informational meeting. Okay. He was responding to a question from Representative Redmond about community and the potential for opposition. And answering said the state wanted to secure community support before moving forward and would not sign any contracts or lease agreements or start making investments until we know we have the support to do so, adding that's crucial. As I said, if you get the time, please take a look at the video clip, or perhaps we could play it later if we have time. So in the period after the town informational meetings, which took place February, March 2021 now, the residents of the town completed a survey that was put out regarding the facility, where over 300 have indicated opposition, and not only they oppose it, they'd be willing to sign anything to that effect. That was one of the questions we asked. This is a huge number for Newbury. You have to understand, 300 people is more people that usually turn out, the full turnout for most elections. And actually going back through the data, with the exception of the two general elections, presidential elections, it would have been the clear majority in all of them. All but one. And so it's actually, if you look at the data, based on the number of respondents and town population, it's 93% opposed, 5% undecided, and the rest not opposed. Doesn't necessarily mean they support it, but they said they were not opposed to it. In fact, some of them put comments into that effect. So it's a very small number who actually would express support. And this is like a 99% confidence interval, plus or minus 3.5% margin of error. So if the town voted on it, we know which way it would go. And the point to make here is that, we have a map, which again, I put in the back of my package that I sent, the back page, if you could look at it at some point. It shows the distribution of all the people who responded, superimposed on a map of Newbury. Because the point was made by DCF early on, well, this is just the locals. These are the people who live 1 mile, 2 miles away. So we literally put a 1 mile, 2 mile, 3 mile radius on the map, spotted everyone on it. And there's more people outside those circles than inside it. This is a true town-wide thing. It's not just a proximity issue. And it's also had an interesting effect that it's completely unifying in the town. Socioeconomic, political lines, it just crosses everything. It's like virtually everyone is in total agreement with it. So Faced with evidence to the contrary, Commissioner Brown basically said he has support and will move forward. He said it to the media fairly early on, and he told me this personally on Saturday, October the 2nd, saying, and I'll paraphrase, I just spoke to someone who supports it. I have community support, which, you know, this is in a room of 100 people plus another 50 something on Zoom who will oppose it. It's actually quite laughable if the implications weren't so serious coming from an administration official. So in the memo I referenced earlier, there was a sentence that said, we also understand there are community members who believe as long as there is any level of opposition, we should not proceed. We respectfully disagree with that premise. Okay, so any level of opposition being greater than 90% of the town, which is overwhelming by any measure, right? They are respectfully disagreeing with the basic principle of democracy to justify moving forward. And in fact, if you look at it, it's the converse they're really proposing here, is that if they can find anyone who say they can support it, no matter how few, then they can proceed as they have support. I mean, to me, that's just unbelievable to be even stating that. One thing I said to Commissioner Brown is that let's put it to a vote. I mean, if Windsor can get a say in the future, why not Newbury? I mean, it's one of the things that I'm confident that if it was voted on, we know which way it would go. But there was another statement in that memo from DCF to Ginny Lyons that basically said, we have been completely transparent throughout the process. I really do have to take issue with that. There's many examples of this where it's not been the case. One thing said to the legislature, another to the media, another to the Newbury community or the permit authorities. And again, I have a whole list. I could go through them. I just want to hit a couple of them. But the whole process has really been shrouded by doublespeak, euphemisms, and misrepresentations. You know, from the beginning, there was a wholesale misrepresentation of the true purpose of the building. It's a detention facility for some very dangerous youth, right? That's come up quite a lot. And by the time we got to the community meetings, we were being, you know, it's an educational facility for children. I mean, literally, that was the language that was being used in the first meetings. And one step further now, it's a group home where all the kids are mentally disabled. The thing is, people cross-reference information here. I mean, you can't say one thing over here and another thing over here and expect to get away with it. There's too many examples of open, candid discussion about youth dangerousness in the oversight committees. If you listen, which unfortunately I've been spending a lot of time listening to hearings over the last year, the level of youth dangerousness is a constant topic of discussion right now. Yet, by the time it comes to the town, it's youth who lost their way or made a bad choice, and frankly, attacking residents who use the same descriptions as the Commissioner or Senator Sears in hearings, often criticizing their own words when they're repeated back to them. It's an interesting situation. So just last week, Senator Sears described the target population of this facility as, I'll use the term kids, but they're serious youthful offenders. Just one of the many similar statements that have been said over the last year, totally downplayed in every conversation with the community. They've continually said we're lying about the term detention center, as I said earlier. And there was a special Senate Judiciary House Human Services meeting in February 2021. The subject was aggressive behavior of juvenile and danger to staff, right? This was openly discussed. Beckett were part of that discussion. And they were going on and on and on about violent incidents against staff in the facilities. And some of them were pretty graphic. This was only days before the first town meeting. And they were openly discussing how dangerous, and then took the complete opposite position, trying to convince the community that there was no likelihood of any issues whatsoever. These are just kids who've made a wrong decision. And pushing back strongly when we were using similar words to describe potential occupants. And interestingly, though, Beckett did note during that meeting that in the emergencies, they were fortunate to have the police respond quickly, which, of course, isn't an option at Newbury. Quickly is an hour. So in the community meetings addressing concerns about security, basically elopements, I'll use the term, the euphemism. Commissioner Brown's emphatic that we should look to Woodside as an example, as it was a secure facility. Okay, I get that. And the number of escapes, he said in a written response, is likely to be a very rare occurrence. However, shortly before he said that, he had been quoted as saying, Woodside has had plenty of escapes. So you can't have it both ways. We will cross-reference. So there's conflicting answers on why the prior VACN program at the site was closed. The legislature was told it was coordinated with this project, but the town was told it was not related. Beckett said at the town meeting there was no negotiations prior to VACN closing, and they'd begun shortly after the closure. But this directly contradicted what Commissioner Brown said to House Corrections and Institution literally days earlier. I mean, you got to wonder why. I mean, it's such a benign thing to misrepresent. I could go on about this, but I'm not going to. But the message is all the descriptions, euphemisms, conflicting stories over the year have compounded and created an atmosphere of total lack of trust, which is entirely their responsibility and be very difficult, if not impossible, to recover from, in our opinion. So the DCF statement to Senator Lyons that DCF has engaged the community in a meaningful way and have been completely transparent throughout the process, in my opinion, is clearly questionable and frankly just another misrepresentation. So one other thing I'd just like to touch on, totally unrelated to anything I've said, cost comparisons. And this is a big deal. It's part of the process, looking at the cost of the buildings. And, you know, I hear the quote that it's going to cost $3.8 million a year for Newbury and $6 million for Woodside. But the way I'm looking at it now, that's not the whole picture, because most people, if you listen to a lot of the hearings, most people thought the Raise the Age kids were coming to Newbury. Now they're not. That was a commitment made, and I don't think Beckett even wanted them. So any cost comparison, if you're comparing Woodside with Newbury, it has to be Newbury plus whatever you need to do the Raise the Age kids. And conversely, if you're looking at a forward-looking cost comparison for another facility, you have to do it the same way. It's got to be, you know, you've got to consider the separate facility. So any future facility that would be combined relative to what Newbury plus the other one is today. Hopefully you get my point, but it does need to be factored in. And I don't think it has been in any of the cost comparisons that I've seen on this project so far. So looking back, I guess it's now apparent DCF has squandered over a year of time the state didn't have by not openly disclosing the facts to the legislature relative to the viability of the chosen location for this use. And even when directly questioned about it, they also didn't consider basic contingency planning. Importantly, they've also squandered a lot of goodwill in town, and I don't think they'll ever be able to establish a meaningful relationship with the community regarding this facility based on everything that's happened so far. They seem intent on enforcing a detention facility onto Newbury despite the permit denial. I won't even go into the whole civil rights thing again. It's absurd. But many in town were really upset when they saw that as, you know, that article is, you know, state-sanctioned bullying. Both the municipality and the community have filed notices of appeal through the attorneys to actually fight the appeal. And that's all I'm going to say on the appeal. Despite what they said previously, when the legal process played out and the decision did not go their way, the state came back with a heavy hand to attempt an end run to reverse a legally sound and well-reasoned DRB decision. That's unconscionable, in my opinion. But even if the project is forced through somehow, the site still has all the other issues and incremental costs associated with it because of where it's located. It's so far removed from services that the state had agreed to pay extra for them over and above what would be needed at another location, and also pay for a private security personnel for Beckett. And it's totally at odds with the community, and somehow this is still the best location. So, in my opinion, all the additional payments for services and paying for private security that DCF have agreed to along the way is actually tacit acknowledgement that the location is not appropriate. That's to perpetuity. Sticking with Newbury and moving forward on this is not the best and most expeditious option for the state when there are other viable and more flexible options available. I'd be surprised if anyone in the legislature would condone this course of action once all the facts are on the table. To reiterate, Commissioner Brown has confirmed the state is paying for the appeal. We recognise that a secure facility is still urgently needed, and the major gap in the state system of care for youth is extremely unfortunate. However, the responsibility falls squarely on the administration and DCF for prematurely closing Woodside without a viable plan in place. The situation DCF has created in Newbury is not Newbury's issue. And the fact that DCF's now scrambling to fill the gap shouldn't be in any way a factor in the zoning or the appeal process. DCF has a responsibility to abide by the zoning regulations that exist in Newbury. Unfortunately, they tried and are still trying to circumvent them. Newbury opposition is not emotional and fear-based, as DCF have mischaracterized, but pragmatic, measured, and service and ordinance-based. If you only need to look at the many thoughtfully written submissions by Newbury residents to the DRB and the Act 250 Commission and the legislature to see that. So many things haven't seemed right with this whole thing. Why are we trying so hard to make Newbury work? Why are we willing to commit additional tax money to make the remote location work? Why are we doubling down on the location effectively? It feels like, my opinion again, it feels like DCF's position is becoming a point of principle rather than pragmatically addressing the real state need. Who knows? Something's driving it. In a previous letter to the town, Commissioner Brown said, DCF has no interest in using a strong-armed approach or misrepresent the truth if the permit was not approved. But when faced with the DRB's well-reasoned and legally sound permit denial, coming as no surprise whatsoever to Newbury's residents, it seems DCF has decided now to do both. So I've only the most basic understanding of the legislative process and how oversight works. But I do have a question. Now we know the facts as presented were not correct. Is that reasonable to assume it should be grounds to rescind the approval and revisit the project? Pushing forward, it seems the administration is willing to condone misrepresentation and enable a benefit from it. That's key. We urge the legislative oversight committees not to do the same. The legislative approval of this project was based in part on a false premise, and we believe the approval should be rescinded and the project reassessed to maintain the integrity of the overall process. So in closing, I promise, I urge the legislature to consider the following points. The administration based the project on a falsehood and is now perpetrating another to force it through. The facts are on the table and clear and obvious. We urge the legislatures to respond to this. The assertion that the facility is a group home for those with mental disabilities is clearly incorrect and should be rejected. That mentally disabled is being used to describe the entire target population of justice-involved youth is clearly incorrect and should be rejected. I urge the committee to recommend to the approving committees that they rescind the legislative approval memo due to the false pretext and the project reevaluated. Commissioner Brown should be held accountable to meet his commitment not to move forward without Newbury community support, and there should be an immediate stop to state taxpayer payment for legal costs of the appeal. It's in the best interest of the state that an alternate plan in a more appropriate location needs to be kicked off now rather than wait for the results of the appeal. And with that, I'll close, say thank you very much for your time and the invitation to testify. And if anyone's got any questions, I'll be willing to answer them.
Tony, just let me say immediately, I have located your witness list, so I'll take the reins back over in presenting the order.
Okay.
I want to be, I guess, as clear as I can possibly be for all of you that have never been in the legislative process before. When decisions like this are made, they are not made by one committee. They are not easily gotten through the legislature at all. It's a laborious, time-consuming, often frustrating process. This committee is the Committee of Institutions, which has walls built up around it, if you will, regarding our jurisdiction. Our jurisdiction is limited to the question of brick and mortar. Does the brick and mortar meet the policy statements that have been made by another committee? The approval process from our perspective boiled down to, does this building meet the needs of what are being presented to us? And it doesn't go any farther than that. So the conversation that you're having with us today, while we are becoming educated, we are not the final arbiters of that question, especially at a time when you are in the midst of litigation over this subject. I know that sounds frustrating, but I have to give you the clear understanding before you leave that this committee's jurisdiction is limited literally to the brick and mortar questions. So if you're going to continue the conversation, it should be in front of the policy committees that you go to next in order to have that conversation. And that is frustrating, I understand, but that's the way the legislative process works. Each committee is a silo unto
Yeah.
itself. And that's not that we're trying to just dismiss what you're bringing to us. That's just the process. And we are often frustrated with that as well.
I think I'm learning quickly, Senator Benning. I've had a crash course in how things work, and I recognize this committee isn't one of the approving committee.
I also want to point out the practicality of a group like this meeting. I have a time limitation. Today, it happens that we are scheduled for a 4:30 training conference for the senators. I want to make sure that everybody that's on the screen has a chance to say something and we get the committee's questions answered. Senator Mazza's had a hand up. So, Tony, I'm going to let Senator Mazza ask you a question or make a statement, whatever he wants to say.
Tony, were you told that you could change the decision of this this location? Because it sounds like this is something else that's out of our hands completely. So your presentation is almost made for the court at this point. I don't know.
That wasn't the intent. No, I'd not been told that. I had no expectation of that. I was just trying to put some context to what I thought was the approval process and how I thought it was questionable in terms of the information presented.
Most of these things you brought up are all legal terms, and it's way over our jurisdiction. And I just wondered what you were promised today.
No, I wasn't promised anything other than a voice.
Thank you.
Committee, Senator McCormick.
Thanks, Mr. Chairman. My perspective is 20 years old, and perhaps things have changed. But my understanding of this kind of a question goes back to the placement of the Southeastern Vermont Correctional Facility, where which was an educational exercise for me. It's when I first realized that municipalities are creations of the state. Their powers are delegations from the state, and that basically the state can put a facility wherever it wants. But that we have in Vermont a long tradition of the state at its discretion, generally respecting the will of the local community. In the case of the Southeastern facility, the target communities were Windsor and Springfield, both in my jurisdiction. And we didn't have to do it this way, but we chose to have a policy that we would not put the prison where it wasn't wanted. And there were votes in Windsor and in Springfield. Windsor said, no, thank you. Springfield said, bring it on. And I'm wondering, it seems to me that because we can does not necessarily mean we should. I'm for one, and that was a decision of the Institutions Committee. Now, maybe that's changed since that prerogative, but that was the Institutions Committee deciding where to put the brick and mortar was a brick and mortar decision.
I agree, Dick. It falls within our jurisdiction about the placement of the unfortunate circumstances we find ourselves in is that we approved the process of the state going forward to apply. But my understanding when I left that meeting was it was with the proviso that the town was going to be on board. And that's where there's an issue. I know that very question is subject to litigation. So I'm a little nervous crossing that line because I have been told by the commissioner that they have a dispute about whether or not how they did, and what they got in response was their understanding at the time that they came to us. The litigation, the fact that it exists now sort of takes this out of our hands. I'm trying to give these folks the opportunity to vent whatever frustrations they may have. But at the end of the day, the conversation about revoking something is, in my eyes, lying in the hands of the court, not us at this stage. There may be other committees that have the policy handles and may make a decision about whether or not something there was done in such a way that they want to take another look at it. As I sit here right now, though, I'm very nervous that we are walking on the lines of the litigation that's been filed. And I don't want to make anybody any promises. I do want to hear what you have to say. Certainly, this conversation as we go forward and put facilities in other locations will definitely drive the conversation when we question state officials and what the intent is and make clear on the record about what's supposed to happen. I just have to tell you as a lawyer, and I know this sounds frustrating to people who are not familiar with the legal system, but when you get something into litigation, the legislature has to be very careful on how it discusses things that are literally in front of a judge. And so I'm doing the best I can, guys, to give you the opportunity to speak up and tell me your frustrations if you want. But I have to come back and say, this decision ultimately right now, as I see it, is in the hands of the judge. Unless and until somebody convinces me otherwise, I have to leave it in that fashion. I also, unfortunately, don't have a whole lot of time today to be in a back and forth argument about that. And I regret that because it's just one of those things that we have something else going on today. And I want to make sure everybody is at least heard initially. And it may be that we have to come back and have another conversation. But for today's purposes, anybody else have any questions for Tony? If not, Brad, I'm going to move on to you. I will not try to eviscerate your last name. So help me out, please. And welcome to the Senate Institutions.
Let me first see if you can hear me well enough.
Yeah,
I live where there's very poor bandwidth and no cell service, which is important to this discussion, by the way, because it'll come up in conversation with other people. The whole idea of a secure facility having some kind of an amber alert when lots of us have nearly nothing for communication is relevant. So my last name it's Brad Vici, like Quici. Been a resident of Orange County since 1968, resident of Newbury since 2005. For the old farts like me, my family used to own the rare bird animal farm in Fairleigh. I live on Scotch Hollow Road, just over the hill, literally out this window, 4,000 feet up over the hill, and my property and the proposed property, the Beckett property, are connected by a historic road that used to be concurrent with my driveway. And about 10 years ago, big chunk of that was renovated, widened, and turned into a logging road for my next door neighbor who owns the property between me and the Beckett property. And just for what it's worth, I'm also an elected town official, having served 4 terms as the town moderator. I'm going to have to sort of edit my comments as we go.
Brad, let me stop you for just a second. I also am a town moderator, and I just want to point out for the public who may be watching, neither of us in that capacity officially represents the town in a legal proceeding, so that you are perfectly safe having a conversation here today.
Yeah, absolutely.
Thanks.
I do not represent the town, and I'm not trying to portray that. I thought it might lend some credibility to some people in town, think I'm an honest, decent fellow. I like Tony. I mean, I'm going to try to not repeat things in the interest of time. And it's also, I mean, I can sense your frustration that stay in your lane with brick and mortar BGS concerns is, and the silo of this committee is cumbersome, but we'll have to deal with it. I'll try to not stray over the line very far. I'd like to frame this discussion in terms of the state of Vermont awarding a $40 million contract to a private out-of-state business in an inappropriate location, despite misrepresentation of their existing permit status, and look at alternatives to pressing forward here in Newbury. And some of that may be beyond your jurisdiction. I don't think I'm going to say anything that would interfere with legal proceedings underway. That is the appeal to the state environmental court. The basic idea has come up, you know, in the broadest picture, the 30,000 foot view, why Newbury? And Commissioner Brown has said before various committees and at our town information meetings that, and I'm paraphrasing here, Beckett owns the property and already has permits in place for their operation there. And unfortunately, only one of those statements is true. So Beckett VPI does own the property over the hill from my house, but they don't have permits in place for the operation they've been conducting there. And that is the basis of, I think, a lot of our concern, that all of this was presented to you as if it were going to sail through permitting. This would be built very quickly because they had permits in place, which was not true. So where does this information come from? And the first instance that I can see in the most recent history, since we became aware of this at the end of 2020, was at a Senate Judiciary Committee meeting, January 26th of last year. Jay Walter of Beckett Family of Services, the quote is, the actual legal zoning issues here are actually very minor because we have a permit in place for this particular use already. And that's not true. And then a couple of weeks later, February 12th, before a House Committee on Human Services, Commissioner Brown had said towards the very end of the meeting in response to a few questions, and I quote, "It is already permitted as a residential treatment program in their community because it was operating as such." And again, half of that statement is true. It was operating as a residential assessment facility, but without a permit. And I think there may be people that are confusing the fact that the operation that was then called the VACN, the Vermont Assessment Center at Newbury, was licensed by DCF, and because they had teenagers in residence, they were required to educate them, and so they were also licensed by the State Department of Education as a tutorial site, but that's not the same as a land use permit or a zoning permit. So the current land use permits, Tony touched on this, are for a pre-vocational outdoor and experiential education center. So essentially some sort of a school. And if we back up a few years to look at how did we get here, in 2013, Beckett had by then already taken over the management of the Bennington School and was turning that into the Bennington School for Girls and the New England School for Girls. And the boys were leaving the Bennington campus, and the plan was to bring them to Newbury. So they would then be housed at the building in question, at the former Whipple Tree Bed and Breakfast on Stevens Road in Newbury. And that was all done under the auspices of the Connecticut River Academy. And Connecticut River Academy was a privately managed alternative school, alternative middle and high school on Route 5 in Bradford. And most of us thought that it was actually part of our local school district. And so it was serving the local school districts as a day school. It had no residential component. So a student there could be from Oxbow, could be from Woodsville, Piermont, the surrounding towns. They'd go home, they lived at home. It was not secure, and it was not considered a treatment facility. At that time, the plan to move the boys from Bennington up to Newbury into a building that was then called the Newbury House. They applied in 2013 for a zoning permit to run a teen assessment center there. And they were not given that permit. They left that process with a permit for a pre-vocational outdoor and experiential education center. So in essence, a school, and it was the permit application was not in the name of Beckett Family Services. It was in the name of Connecticut River Academy, which is a subsidiary of Beckett, one of many, which adds to the confusion about all of this. That permit had very specific language, and I can quote, "By maintaining this 278 acres as an outdoor classroom for environmental and agricultural studies, the project meets the goals of the town plan." And so the Newbury House operated from 2013 to 2018 as a dormitory for Connecticut River Academy. And the idea is that every day the students would get into a van, go down to Bradford for educational instruction at that facility until 2018, when the Connecticut River Academy was closed due to lack of compliance with state DOE guidelines. And that is when the Beckett folks switched operations and began operating the facility as the VACN, the Vermont Assessment Center at Newbury, without a permit and without the proper paperwork and paper trail for the change of use. So as Tony alluded to, Beckett, VPI, Connecticut River Academy, 6 or 7 relevant names here, is well aware of this because in 2020, they applied for an Act 250 exemption. They spoke to Linda Matson down in the District 3 Environmental Office to try to avoid having to do any kind of Act 250 review and hoping for a minor change. And initially they were granted the fact that that was a minor change. And eventually the process required them to go through a new Act 250 hearing. But they had applied to change the use from an outdoor education facility to an assessment center, knowing full well they lacked the permit to do that. So, I think Beckett has worked very hard to develop a positive relationship in some communities. I know Senator Sears referred to that down in Bennington, but in Newbury, they have not done so. They've been very quiet. I suspect, without any proof, they've been sort of operating under the radar because they know full well that they're operating outside the confines of their current permit and in violation of that permit. So regarding this proposed facility, we held 3 informational meetings by Zoom back in February and March of 2021. I didn't even know about the first meeting until after it happened. So there were lots and lots of Newbury residents that were not able to participate. And even when they got a hold of this for the second and third meetings, I was unable to get a question in because so many people were lined up, 3-minute warning, the time constraints. This is the COVID pandemic we're living with. And a few questions did come up. And one of them came up by a Newbury resident, which was, well, just in broad strokes, well, what about Windsor? And the response we were given by Commissioner Brown was that was all about renovating the old cell block building, that huge building that's way too big for a 6-bed facility, doesn't have the kind of look and feel for a therapeutic center that they were after, would be way too expensive. And it was mentioned at that time that the state had plans to renovate those buildings for offices for other departments like Fish and Game, and possibly even a mixed use as commercial space that could be rented out. And this is months before the eventual study came out at the end of the year. The follow-up question was, well, why not build a new facility? And the answer we were given by Commissioner Brown was jumped right into the idea that, well, we have to do land acquisition, Act 250 and other permits, all the infrastructure, roads, water, sewer, electrical lines, infrastructure like internet. And the question that was, and that would be very expensive, that would be somewhere in the vicinity of $12 million when they added in all of the land acquisition stuff and unnecessary delays. Of course, the whole idea was to get this built quickly to address the urgent need that we've all heard of. The question that was not asked, it's partly because I couldn't get in and get my question in at those meetings, was why not build a brand new building, a purpose-built building on state land in Windsor, where there would be no cost of acquisition, where you have all of the infrastructure needed, access roads, water, brand new water system, water, sewer, a local police force, which we lack here in Newbury, and a police force that for many years, dealt with a prison, a possible workforce that was already experienced in, de-escalating very difficult and dangerous situations that could possibly be trained for a more therapeutic role, and even a perimeter fence. So there were options that weren't really discussed at that time. And I'm going to skip over the irregularities and the conflicting information that we got about the closure of the building and the closure of the VACN, because I think, as you've stated, it's process and it's programming. It's really not brick and mortar, but they did close that building down. And questions have come up about, whether or not the closure of the VACN was coordinated with DCF to bring this new proposal on site. And we have heard answers that yes, it was, and no, it wasn't. And that just leads to the confusion and our inability to trust what we're hearing from the major players. I'll skip over the bulk of it, but just last week, despite having said that no, we did not close one program down to make for the other, and bold statements by Jay Walter of Beckett back in March of last year, I can unequivocally state there was no advanced discussion with DCF about closing our facility so this facility could be established. Frankly, when we shut the program down, it was for economic reasons. Went on to say they were frankly losing money. Later in the same meeting, Jay Walter added, and with a kind of angry tone, if you watch the recording of the meeting, he said, I do want to affirmatively address any implication that we sort of behind the scenes cut a deal with DCF regarding this. First of all, we would never do that. And secondly, I think too highly of Sean Brown and his team to allow that comment or that suggestion to be implied. It's just not true. So that made us curious. If it were true, how bad would that be? I mean, it wouldn't be such a big deal if DCF said, hey, you know, you've got a not very well performing system here. Why don't we shut that down and work together? So I don't know, maybe there's a hint there about whether or not that's an inappropriate thing to do. Just last week, when Representative McFawn and Jessup asked questions about spending money to maintain the current building, even though there is no approved program there yet, then Commissioner Brown said, they've taken that property offline to hold it for our use. They're suffering a loss, and so this is part of that. Then in responding to a follow-up question by Representative McFawn, Commissioner Brown said, because they were running another program in that facility, and they shut that down to allow us access to start the design work and the other work involved in that project, that sounds determinative and it sounds coordinated. I'm going to ask, I have no idea. Would that be a good thing or a bad thing? It doesn't alarm me if I, as a resident, thought that they were shutting down one program to start another, but the adamant nature of Mr. Walter's response was really troubling. So let's go back to what about Windsor or Woodside? Because that's really the brick and mortar questions. At our first informational meeting held by Zoom, it came up, why not use the Woodside property? And Commissioner Brown said that the site is too big and too expensive. That site is appropriate for a much larger facility, which we really don't need. And yet, in the months since then, in the 12 months since then, it now looks like DCF has to build two facilities, one for minors and one for the raise the age young adults. And he's stated emphatically that they're not going to be treated together, that they have to be kept separate. Okay. So
Brad, can I just stop you for a second?
You bet.
Just so you know, we have Representative McFawn coming in to explain his bill. That's a conversation that maybe I'm going to suggest, just for time purposes, I don't want to go down that road today. I'll let him explain why he's brought the bill and having that conversation, but I'm reluctant to have, with little time that we've got left, witnesses today trying to make a pitch for some other location to be the location for this facility.
Sure
I
enough.
promised Tony I would give people an opportunity to vent their frustrations about why Newbury.
Yep.
But if part of the testimony is to say, let's put it over here instead, that's a whole other conversation for a whole different group of people. And I just want to make sure everybody's got the ability to say what they want today. I'm sorry for interrupting, but I just got to move this along somehow.
Right. I'll get right to the conclusion then, because essentially, if you look at, Newbury versus other places, we don't have the infrastructure that's necessary. We don't have a local law enforcement presence. When we call an ambulance, it's a New Hampshire ambulance service based in Woodsville. They take people to Cottage Hospital in Woodsville. In Woodsville, if someone has a major mental health crisis at that time, then what happens? They're in the state of New Hampshire. I was told by the Woodsville ambulance director that means they transferred them to a facility in Concord or Manchester, not a facility in Vermont. So there's some very interesting twists to how this works because we're a border town. But ultimately, my concern is that I'm concerned about placing a business in a conservation district where it so clearly doesn't meet our zoning. We were assured this would not go forward without community support. I don't think the community support's been demonstrated, and that we have now turned it down. Our DRB has done so, and that's all in litigation. As a Vermonter, I'm just concerned about this proposal being based on permits that don't exist. I don't know which committee of jurisdiction is going to look into that, but if we award a $40 million contract on the basis of misinformation, that is then carried forward and repeated at many levels, I'm very troubled by that. I think that puts us in a position where we as Vermonters can no longer trust our own government, and I find that very troubling. So thank you very much for the opportunity. I await others' answers.
Brad, thank you very much. Committee, 2 questions. First, we've been at it for about an hour and 15 minutes. Does anybody need to take a break? I don't see anybody hollering, so we're going to continue. Second, is anybody got any questions for Brad? I don't see any hands. So at this point, my next witness, as I understand it, is Marty Peterson. Marty, are you on the screen?
I am here.
Welcome to Senate Institutions. You're up.
Good afternoon. Similar to others, I am a civil engineer by education and training. My wife and her extended family have owned the property at 1143 Fish Pond Road and the surrounding acreage since 1958, some 63 years. We are approximately a half mile from the property boundary. Our understanding is that the multiple ponds that run through our acreage were established in the early 1900s, and they provide the basis for the Fish Pond Road name. The proposed permanency initiative is located and provides the headwaters as indicated on a wetland jurisdictional map from 1977, and also provides the source waters for those ponds, as well as I understand from others that the terrain in and around the Stevens Place is designated as bear habitat and a wildlife crossing. Those are all issues that do pertain to the configuration of bricks and mortars and ultimately permit applications. Through my 30+ year professional career, I've managed construction projects along the US Eastern and Gulf coasts, Caribbean, the Mediterranean, and the Middle East. I've run projects from a couple $100,000 to the largest, which is more than $5 billion. In the past year, I've testified as a subject matter expert in the state of Connecticut regarding offshore wind and port development and the associated permits and construction. In each of those projects, a design is undertaken in compliance with a series of building codes, environmental regulations, zoning, and use requirements, all of which is used to establish the configuration and the orientation of the bricks and mortars, how they're placed. These codes, regulations, zoning requirements have all been generated, debated, approved, and are then utilized like we are doing here at this town, in the county, in the state, and throughout federal levels. Why? To create a uniform and a standardized method of assessment for compliance for the betterment of the workers, the public, the state, and at the end of the day, our democratic country. There are many places in the world that I have worked with that don't have this uniform assessment. And on select times, they often bend or dismiss those established rules. I have worked for those named King and Amir when they adjust those programs based on their needs. And much of what we're here today is a similar manipulation of the facts in order to establish the use created by those bricks and mortars. So we've talked about the DRB and its unanimous denial. Following that denial, WCAX News on November 19th, 2021 stated the state of Vermont is appealing DRB's denial of the proposed youth detention center. DCF says they are appealing the board's decision, but is also making contingency plans for another facility if the appeal fails. As a brick and mortar issue, the state does have the ability to implement its contingency plan, whether the issue is in front of the court or not. That is a state decision that could be made that would end or otherwise alter that process that is in the courts. Furthermore, the DCF commissioner stated at that November 19th timeframe that this is the right location for the program and the facility. Per that testimony, Mr. Brown went on to say, juveniles served at the proposed facility would not be free to leave on their own accord, nor could such juveniles be dismissed from the facility by the applicant. As a brick and mortar issue, they have stated that it's a residential facility. The brick and mortar and the components of that facility will dictate whether it is a residential facility or, as we articulate, it is a detention facility, and a detention facility is not in compliance with the zoning CD 10. Furthermore, the appeal submitted by Mr. John Anderson, attorney for Vermont Permanency Initiative, states the following. Attached for filing is a notice of appeal of the decision by the DRB denying approval to locate an existing building, a residence to be licensed, as we've heard before, up to 6 adolescent boys with disabilities. It goes on to state that in particular, the residence should be treated as a single family residence as provided by statute VSA 4412. A provision to prevent discrimination against disabled people. I'm sure, or I hope most of you have read this, eye-opening for me. After reading the appeal, taking the time to review that statute, Title 24, Municipal and County Government, 4412 is required provisions and prohibited effect. It states 2 components not raised, of course, by Vermont Permanency Initiative. The first is that municipalities may regulate and prohibit expansion and undue perpetuation of nonconformancies, i.e. this detention center is a nonconformancy. And number 2, nothing in this section shall be construed to restrict the authority of a municipality to abate public nuisances or to abate or remove public health risks or hazards. The hazards are clearly laid out in DRB's 7 findings that highlight the lack of services and the potential undue harm to the community. Our neighbors on Fish Pond.
Mark, can I just
Yep.
stop it for a second?
Sure.
I'm going to reiterate what I said earlier. You are making a wonderful legal argument from a lawyer's perspective. I'm very impressed, but you are literally placing us in the position of having to hold the gavel in our hands and deal with the situation as a judge will. And
Well, then I will just close, if you don't mind, sir, so others can speak, if that's okay.
I didn't want to be rude and interrupting you. I just have my own ground rules for what this committee is supposed to do and what it's not supposed to do. And I really get nervous when we are dancing on the edge of that court case. I appreciate the attempt, and I do not want to dismiss or come across as sounding rude. I just have legal ground rules of my own that I have to be able to abide by. So if we could move on to anything else you wanted to say, I would appreciate it.
DRB summarized its findings and conclusions, and we would like to suggest that you could reorient and state that those findings are as such. The proposed brick and mortar for the facility does not result in a residential care home or group home. The proposed brick and mortar is not a state or community owned or operated institution or facility. The proposed brick and mortar as constructed is not a public or private school or other educational institution certified by the Agency of the Education. The proposed brick and mortar is not of the same or more restricted nature than the existing non-conforming use. And the proposed brick and mortar is not allowed as a conditional use within CD 10 district and is wholly inconsistent with the purpose of that district And lastly, and in my opinion, most importantly, the proposed brick and mortar for this facility will create an undue adverse effect on the capacity of the existing and planned community services. It will create an undue adverse effect on the character of the area, and ultimately will create an undue adverse effect on the traffic of the roads and the highways within the vicinity. With that, I appreciate the time you provided and the opportunity to better inform the committee. Thank you.
Marty, I appreciate it. Any questions for Marty? I see no hands. The next person I have up is Susan Kulp. Susan, welcome to Senate Institutions.
Thank you, Senator Benning, and good afternoon, all the members of the committee. I really appreciate the opportunity to speak. My name is Susan Kulp. I'm a resident of the town of Newbury. And just to clarify, before I get into my remarks, discussions about zoning and the location does fit within the bricks and mortar sort of scope of your committee, as I understand it. At least I got that impression when Senator McCormick made his remarks earlier. So is that something that is useful to continue to discuss and to speak about?
I am happy to allow you to speak about it. If I get the feeling like we're approaching, in my legal world as an attorney, when I say Your Honor, and I know who I'm talking to and who has the ability to bang the gavel, if we get to that point where I feel like we're being asked to bang that gavel, that's where I'll probably jump in.
Okay, I'll try to avoid that territory. So anyway, like my neighbors, I was upset to learn about the plans for siting this project in this particular location in Newbury. And I was pleased that the town of Newbury's Development Review Board reviewed the project dispassionately and found that it did not comply with land use law under several independent grounds, and on that basis denied the permit. And honestly, I'd hoped that would be the end of it, since Beckett executives themselves had said in their statement to the DRB, let this decision be made by zoning law and land use considerations. And they implied that they would abide by that. Now that the decision has been made by exactly those criteria, it's very disturbing that they and DCF are seeking to overturn that ruling. And so I won't really go down that road, but what Beckett and DCF were asking the Newbury DRB to do was to approve unlawful spot zoning on their behalf, allowing Beckett to operate a business that isn't allowed in the conservation district. And, you might expect a private company to, go ahead with an appeal of a decision like that, but it's way more disappointing to me that the state of Vermont is supporting that. And again, as others have said, there's no disagreement within our community that a facility of this nature may be needed somewhere in the state to serve these needs. However, I believe strongly that the state should not be steamrolling local land use laws in order to site facilities where they cannot be adequately supported and where the land use is at odds with a town plan. And testimony from the town select board to the DRB outlines specifically some of the services that would be burdened by the placement of this facility in Newbury, ranging from emergency response and fire protection, road maintenance, waste disposal. And as someone said, Newbury has no police force. We contract for limited services with Orange County Sheriff's Department, and the facility was just simply beyond the capacity of our town to support. There are many essential facilities and services operated by the state, as well as by private institutions and private businesses that serve broad public needs. They need to be cited somewhere. Yeah.
Susan, could I just ask you a question right off to clarify? You said you had contracted with the Orange County Sheriff's Office. I know where that is in relation to Newbury, but most of the people on the screen probably, well, most of the people listening anyway, probably do not. Can you just tell us how far it is from Newbury to the Orange County Sheriff's Office?
I believe it's located in Bradford, and so that's about a half hour away. Police response, when we were asking about this during the process, They estimated it can be anywhere from, if a trooper or someone happens to be driving near Newbury, from like 15, 20 minutes to 45 minutes or up to an hour or an hour and a half if they have to wake somebody up and, get them out here.
Okay, I want to clarify, my understanding is that you have a contract with the Orange County Sheriff's Office. I see Michael Thomas is already chomping at the bit to be able to say something. And I think I know the answer already. My understanding is that the Sheriff's Office is in Chelsea.
Chelsea, okay.
Chelsea, so if you do not know the answer to this, I'll hope somebody else does who follows you. I'd like to know the distance between Newbury and Chelsea. And I know that you were actually speaking about the state police has a satellite office in the town of Bradford.
Oh, that may be. That had been brought up as, one of the places that the facility would draw on for response, as well as the St. Johnsbury Barracks. And I guess those are the state troopers, not the Orange County Sheriff's Department. So anyway, I think Michael knows that best, so I'll let him take on that question. But anyway, no one argues with the fact that there are facilities that are important. They serve vital state needs. They need to be cited somewhere. But I would ask our lawmakers and other decision makers at the state level to adhere to legitimate zoning laws when these facilities are cited, and to respect community plans that are designed to ensure that intensive uses are located in appropriate parts of each community. The purpose of zoning laws is to make sure that these kinds of uses and facilities are cited properly, where they will not create a safety concern to the surrounding community, and where they don't create unnecessary costs and risks and burdens. Otherwise, why do we have zoning laws at all? Why not just plop things down willy-nilly wherever anybody wants? And clearly we don't do that, because we know that such actions would result in dysfunctional and inefficient infrastructure in communities and diminishment of property values. It would damage the integrity of working lands like farms and forests, and it would harm the ecological health of conservation lands. Zoning exists to protect those values. Michael Thomas, my fellow Newbury resident, will be talking more about the years of work and thought and consideration that went into developing Newbury's town plan and the zoning bylaws, and the values this community sought to protect through those laws. And so I just wanted to say that we all rely upon that to protect our investments that we make in our homes and our businesses, and to protect the landscape that we care about and enjoy. I relied upon it when choosing where to purchase land, and I obeyed the guidelines in the town plan and the zoning bylaws when I built our home. We all did. We all played by the rules. So I guess I would ask, as this committee ponders the question of where to place this facility or any facility, I would request that thoughtfully developed land use policies and regulations are not suspended for the sake of convenience, or because it's easy, or because a private corporation wants it in a particular place. I've heard some ideas bandied around about changing the land use laws in Vermont so that the state can override local communities when citing facilities like this. And I believe that's an inappropriate role for the state to take in land use matters. And I would urge lawmakers not to go down that road. It's a precedent that would be incredibly damaging to the hard work that Vermonters have put into planning for the future of our communities and protecting the places that we love. So thank you for your time and for hearing our voices.
Well, thank you for coming. Any questions? I see no hands, so I'm going to move on. Michael Thomas, welcome to Senate Institutions.
Well, thank you for having me. Good afternoon. I see some familiar faces there that I've worked with before in different roles. Senator Benning, Senator McCormick, Joe Parsons, representatives out there somewhere. I'm going to introduce myself and I'll get back to answering your question, Joe, in a timely fashion on coverage for police departments. Again, my name is Michael Thomas. I live in the village of Wells River in the town of Newbury. I will say I am on the town's Conservation Commission. In fact, I'm the chair, but the Conservation Commission, as you know, is an appointed position by the select board. And we, in full disclosure, or I am not in any type of action with the town as far as this legislation goes. So I don't see a conflict there on my statements here. A little more background. Back in the 80s, I did a stint on the planning board, and I've been on the Conservation Commission since the early 90s, and most of that time as a chair. Give a little background. Also, one of the few people probably here that has been to the facility in question. In a previous life, I was a fuel oil driver working for a local company, and we had them as a client. I was also friends with the people who started the business as a bed and breakfast, so I'm familiar with the brick and mortar of the building, and I feel I have a good opinion, a good understanding of what the changes physically are going to do, and I'm going to get into that in a minute. Now, Mr. Senator Benning, to your question, the Sheriff's Department in Orange County is located in downtown Chelsea, Vermont. From the facility I used to work out of loading in Bradford, Vermont, it's on a good day, clear day, dry day in the summer, a good 45 minutes to that facility in Chelsea. In the wintertime, coming up out of Chelsea, going up over the heights of Corinth, Bradford into Newbury, we all know it can take up to an hour, hour and a quarter. A sidebar on that, in my listening to past discussions in Newbury, the coverage for emergencies was discussed with the state police, and they came into hearings and made comments and predictions on their ability to respond. I don't recall ever hearing anything out of the Sheriff's Department, even though that's a contracted agency for the town of Newbury in general. I'm prepared to talk about the town plan because I've had much experience there as the chair of the Conservation Commission. I have helped rewrite the town plan over its last 4 or 5 rewritings, being back to the 80s. In space of time, there's a lot of information there you folks know. And we're here to talk about the brick and mortar of the building. As we all know, as good Vermonters, and you folks have had a lot of experience with this, you can't build a good building without a solid foundation. And that's kind of an around the barn sort of way. But to make a point quickly, I'm going to talk about. This is in the Conservation District 10, which is our most conservative district in the town. Without getting into details of that for this committee, there are more people than the Department of Families and Children that are looking at this, have money invested in this, I should say. And I have to kind of go around the barn a little bit to make this point, so bear with me, I'll be quick. Going back to the 70s, when Interstate 91 was built, that drastically changed the east side of Vermont as far as land goes, as far as habitat goes, and as far as the whole culture of the state goes that way, as far as the habitat. Back starting in 1984, 1991, and up into 2005, the state had been looking at this issue of habitat fragmentation. In 2005, they came up, the Agency of Natural Resources, with the lead of the Fish and Game Department, came up with a wildlife action plan. And that was talking about corridors of travel for migratory animals, birds, and animals in general, as far as patterns go. This property is located just west of I-91, which created a huge barrier in this. So starting back from 2005, I've been on the Conservation Commission that long. We've been working with surrounding towns and the state to talk about and preserving and to get into our planning language ways to, as required by our regional plan out of Two River Ottaquechee, ways to implement and protect those corridors. This is a huge corridor running between the famous West Fairleigh Forest that made the news a few years ago when they put in that place, and up towards Groton State Forest, which we're all familiar with. Back roads and other development through the small towns of Newbury out in the tops in that area have disturbed those corridors, and of course 91. So this land sits in a very important habitat that way. So the state does have, if you can think of it that way, some money invested into keeping this area rural in its culture. Now, getting right into the facility itself to talk about the bricks and mortars, like you said, I've been there, I've been to the property, used to pull right up many times during the year, deliver there, right, turn around the parking lot, saw the activities that went on there different times of day. There was not a lot of schooling, there's not a lot of outdoor education, but that's another story for another day. The fact is, they are talking about in their plan just changing the brick and mortar, the extremities, the outside of this building slightly, fencing, lighting, a little different recreation yard with the fencing, adding entryway, so to speak. So you would think, well, that's not a big deal on a 279-acre property to change the thing, to change the exterior of the building's not being changed much, but it is. It is because of the type of facility it's going to be. There's no going back once this money is spent. And you folks are on committees in the Senate and the legislature there, and in your life, you know how you have to plan. These decisions aren't today and tomorrow, and if some urge this has to be done because Vermont's in a fix right now to find a place for these troubled youth to go. But I'm thinking 5, 10, 15, 20 years down the road, what's this facility going to be? What's this piece of land going to be in this important area of Vermont? Now, for example, over at Woodside, in Waterbury there, when they first built that facility that closed last year, I'm sure they had high hopes and we were going to save you souls and we're going to be this and that. I'm sure they never expected it to end the way it did, but it did. Down at the prison, the southeast facility, up in St. Johnsbury, the work camp. All these facilities had high hopes and long goals, but their lifetime in reality, as far as brick and mortar buildings go, was short-lived. I'm very concerned that if the wrong decisions are made on this property in Newbury, when the state, not if, but when the state changes its mind, changes its idea on how we should rejuvenate these institutional people, that building is going to become obsolete and we're going to move on and build somewhere else that's newer and better and cleaner and safer. So that's going to leave Newbury with this building that's not going to be real sales. You're putting $3.X amount of dollars into it. You're not going to rehab that back into a family home in a conservation district or even a bed and breakfast inn. It's going to sit there. And I know Mr. Benning, Senator Benning, you're a lawyer, and others on the committee have limitations they have to live to. So you look at the facts, but sometimes you get a little tug on the sleeve and you just know you have to pay attention to it. So I urge you folks, you say you don't have a lot of influence maybe on the outcome because of a litigation going on now, but you do walk the halls, you do have ears, you are powerful, and some of the information you can use today in this decision and others, just think about what this is going to mean down the road. Others have spoke well, and I'm prepared here today to answer questions on how much time and energy Newbury has spent over the decades to keep our plan, to keep us a rural community, to keep us a close-knit farm, agriculture, forested community. I can speak to those details here, but the main point I want to make is think about what this building and land is now, even though it's a small piece of that 270 some odd acres, but it does have an aura about it, which is not facts, which is not bricks and mortar, that it's going to retain on that property for a long time. And that's going to leave it a tax burden for the town down the road, possibly, and it's just going to be a negative impact. So I'm prepared to answer other questions on that. I hope I've made my point. And I just hope that you think in the back of your mind, not just today, not just the emotions of the time, because I know you're looking at the facts, but what this is going to mean down the road to a town that has worked for decades to keep itself in the condition of this. And I thank you for your time, and I'm able to answer questions if you have them.
Committee, I don't know if anybody has any questions. Michael, we appreciate you coming. I'm going to have to move on unless somebody's actually got a question. Not trying to be rude, but we are running out of time. And I want to just repeat that the entire Senate is supposed to be in a training session at 4:30. In order for me to make that, I have to get myself home and out of my office. So I'm not trying to be rude, but I am trying to move things along as much as possible. Emily DeLuca, you're listed as Emily Maxfield, I think.
Yes, I'm Emily Maxfield. Hi.
Okay, you're traveling incognito today.
My maiden name is.
Welcome.
Good afternoon. Thank you so much for your time and this opportunity. My name is Emily Maxfield. While we currently live in Connecticut, my husband and I own 6 Bears Den Road in Newbury and are in the beginning stages of building our forever home. Our Vermont land is 44 acres, which abuts the proposed project's property on 2 sides. I come to you today not only as a concerned abutting landowner, but also as a mother of a troubled teen whom, while I pray would never need a facility like this, I also know his possible future reality. I am gravely concerned about this proposed project because of its location and because of the contract that has been happening for it. 5 years ago, when looking at what's now our property, we first bought into the town's plan. This is a place where we want our family to grow. This is where we want massive gardens, chickens, pigs, goats, and a more self-sufficient life, and to fit into the agricultural community that Newbury has to offer. This is the town that we are willing to travel states away to be at. Whether it's on Bears Den Road or across town, we wanted to make Newbury our home. But this section of Newbury and our particular piece of land, which abuts directly to this proposed project, is actually very much more special to us. It's secluded. It's a dense forest of our own with streams and wetlands. Even better, when we bought it, we were told it's conservation land on those 2 bordering sides. It feels like we're in our own little world with no cell service even on parts of it, and cut off from the craziness of the current society. Our kids have a level of freedom on our land with its hiking and quad trails to roam and explore that our place in Connecticut can't ever offer them. The ability to give our 3 children this kind of freedom and independence in the safety of our own land is priceless to us. And most important for our oldest son, who is 15 years old with special needs, having significant mental and behavioral health challenges. These are the reasons we purchased our land outright and are putting everything that we have into building our family's dream. Fast forward to this past spring, when I first found out about this proposed project. I was contacted by a neighboring landowner, also a concerned abutter, who had only just found out. We felt blindsided. I reached out to yet another abutting landowner, and it was completely news to him as well. As abutting landowners, how were we not notified in order to have an opportunity to participate in info and planning meetings? We know this land. We know this area of town intimately, like whoever's making these decisions don't quite know. So we should have a seat at that table to be able to explain things. And how in the world can a high security youth facility be built in a conservation district? I started watching as many recorded legislative committee meetings that I could possibly find online just to be brought up to speed. I was floored each time that I heard GCF tell committees that they had community support. And then when Judy Rex in May admitted to a House Committee on Human Services meeting that there was a community opposition, it seemed to be greatly downplayed. At the time, perhaps they honestly didn't know how much opposition there was because they didn't do a good job at involving the community at all to find out. Beckett and DCF has tried to hide this facility from our community. We are grateful for the legislative for adding the conditional town informational meetings within your approved memo. We learned later, though, through a public records request that J. Walter wanted to hold their town informational meeting, one singular, on the actual day of the DRB hearing, followed by the hearing itself, really blocking out our community's voice. This was alarming in itself. However, what I found more alarming and very disturbing was noticing that throughout these meetings, wordings and descriptions kept changing. During the first presentation, Sean Brown correctly described those who are being placed in this facility as youth referred to this program will be in DCF custody through their involvement with the justice system and will arrive at the facility carrying charges. Some of these youth may arrive presenting with high risk of harm to themselves and or others, and therefore require close supervision. DCF and Beckett answered questions from our community members. They changed the use of words from justice-involved youth to youth coming from through the court system to troubled youth, good kids who have had tough lives, youth with disabilities, and by the end of the first meeting, and what they were being referred to as now is kids and children. That is the language that is being used, being permitted in the hearings and are being used now. J. Walter, on October 1st statement to DRB, made a statement about the residents of Newbury. These individuals have rejected the notion that the purpose of the program is to treat a needy population, and indeed have sought to characterize the home as a prison and detention center. My concern for rejecting this notion is not to not treat a needy population. I care deeply about whoever is going to be housed here, but the play on words has been, it's been so manipulated. The building that is supposed to be a high security youth facility, which is replacing the Woodside Juvenile Detention Center, is now being referred to as a single family dwelling by their attorney. Dwelling, which happens to have bulletproof glass, high security fencing, concrete walls, hard plastic furniture that's going to be attached to the floor, and extreme outdoor security lighting to be high security. These play of words and definitions would be almost humorous if it wasn't such a serious matter, and instead have been astonishing and outrageous. As a mother, I truly appreciate the attentions of this facility, a facility like this. And after watching meeting after meeting, I understand the great need that Vermont has. But this is not the place for this type of facility, and red flags, signs have been popping up everywhere regarding it. When dealing with this level of need, of behavior, this level of, in their own words, dangerousness, which Sean Brown, legislators themselves in a meeting several times had used the word dangerous. Even the best of intentions could do more harm than good and cannot replace true training and vital experience. Beckett has admitted that they do not have experience with these levels of individuals. At both our Act 250 meeting and our DRB hearing, Sean Brown and Beckett admitted that some of the youth that are going to be entering this facility may indeed have committed egregious crimes, including murder, rape, arson, and or more. These are not kids that are like 4 and 9-year-olds. These are teenagers who have adult bodies, adult strength, and have committed crimes that many adults have never even committed. It should be taken seriously. Beckett has, not only have they admitted that they don't have the experience in this level of individuals, but also the company that is building these changes to the facility, they also have stated that they have not had experience with creating buildings with this level of need. So we are taking individuals, youth, young adults that have committed egregious crimes, that have severe needs, and we are placing them into the care of a company that admittedly does not have experience in this level of need, in a building that is being designed by a company that does not have experience in this level of need. And the people who are trained, the people who have experience with this level of behavioral management is going to be an hour away. This is why there's a concern for this town. When we asked for a safety plan, we still have not gotten a safety plan. And at our DRB meeting, I think it was Laura Sappho, I believe. I may get the name wrong of who had said this on their side. One of the things that they had an idea of for alerting the community, being that they're acknowledging that, especially in this remote area, not all of us have landlines or cell service. One of the things that she suggested was that they might drive around, if there was an elopement, drive around and notify the community. I have yet to see a line item for a fleet of ATVs and quads, because in this remote area, unless you're traveling through the woods, running like an escapee, if you're actually coming up roads to our properties, depending on the season, you're going to need vehicles like that in order to notify us. We still haven't heard about, when they're going out looking for somebody who elopes. What about my son who's 15, who meets the criteria of who they're looking for? What if they come upon him? What is the protocol? My son is not able to advocate for himself in a stressful situation and will become combative. What is the protocol if in this area, we are gun-toting area? There's hunters that go out to even their farms and on their trails, and they are carrying some type of protection on them because of the wildlife. What if we were to come across an escapee? What is the protocol so that we're not finding ourselves in legal issues, which I heard that something happened in Vermont recently where somebody held somebody who committed a crime at gunpoint, and now the person who held them there for the police to come is now in legal trouble. There are so many factors that I feel have not been taken into account because of this location. If this location was in a better location and more, I think, thoughtfully of who's going to be running this program, I think that there wouldn't be as much of this grave concern. The company who is designing these drastic changes of this building has confidence that the fence that they're putting up is impossible to climb. I have been in this community of troubled youth for a long time, unfortunately. And I know a lot of people who work in this field, and not one would say anything is impossible when it comes to troubled youth. And there has to be contingency plans. There has to be plans of, okay, what happens if it does get climbed over? Because I guarantee you it will at some point, okay? What is the plan? There is no plan. And that's what's gravely troubling. I am so concerned about the youth that are in this program. Beckett has said that they are going to train their staff, and that's wonderful. They need the training. They're admitting it. That's great. But where's the experience? When something happens, where is the experience of how they are going to manage, de-escalate? And what if it does become physical? I'm afraid for the youth, I'm afraid for the staff, and I'm afraid for the townspeople. And again, because we don't have those services, that backup is an hour away. Newbury is not the place for this facility. Beckett is not the ones to run this facility. Thank you.
Okay, Emily, thank you. Committee, I am cognizant of the time. Jet, Tristan, you're the two people remaining. I don't believe we're going to get to your testimony here today. Unless you tell me you have 2 minutes or less. I don't want to be rude, but I just don't have the time to accommodate you. If you are really interested in testifying, I have a couple of minutes tomorrow at 1:30 if you'd like to come back. But I've got to get my committee off to its training session, and I hate to play the bad guy, but that's just a fact of life I've got to live with.
Senator Benning?
Yes, sir.
My name is Jerry Forkin. Am I on the list?
You are not, Jerry, on the list that I have here.
I was-
You were on a
He-
previous,
he
you
is on
were
the
on a
list.
previous list. And if you are interested in testifying, I can have the three of you back tomorrow at
No.
1:30.
Okay,
I just
can I
cannot
ask
accom-
just one point? I'll be very quick. I am a parent of an adopted 16-year-old boy who has sat in emergency rooms for 21 days of the last month. He's been in DCF custody for over a year. If this is not the committee I need to speak to, then I won't waste your time or anyone else's. And that's what I wanted to know.
I will, I'm going to answer your question.
Okay,
There is a conversation going on right now in Senate Judiciary about the need to have, let's call it a Plan B here. And that conversation is continuing. I would urge you to contact Senator Sears and ask to have that presented. There are a couple of different committees that are working on that angle, including this one, by the way. Right now, I don't want you to come to us feeling like you're going to be able to express something, because what you're asking about is policy, not the brick and mortar of this particular facility.
okay, that's why I didn't know why I was referred to this meeting, but I've been, like I said, I've been here through the whole thing, which is fine.
Jerry, I've got to cut you off because I've got to get my committee out the door.
Okay,
And I
thank
don't
you,
wanna-
thank you, sir.
Okay. I don't want to be rude. I'm going to leave
You're
it.
not being
Jet-
rude.
Jet, you and I had Tristan on here a moment ago. I don't know where you went. Do you want to come back tomorrow?
Yes, I would.
Okay, 1:30 if you would, please. You might be waiting a couple minutes while the Senate gets off the floor and we can reassemble as a committee. I'm sorry that I have to do that to you, but we've just run out of time.
That's
So
okay. Thank you so much.
Tristan, same thing for you? Okay. I will see you all tomorrow. Committee, don't forget, we have training in 31 minutes by my clock, and I've got to get home in order to get ready for that. So thank you all for coming this afternoon. It's been very informative and helpful. We'll see you again.
Thank you.